presiding judges, and distinguished members of the court. I stand before you today to address the following issue. Did the Republic of Erebor violate the prohibition on the use of force under international law through Operation Sparkles? And can the autonomous actions of the Skynet system be attributed to the state of Erebor? This matter touches on the fundamental principles of international law, including the right of self-defense, the rules governing state responsibility, and the obligations of states to prevent harm from being caused from within their territory. Therefore, in my argument, I will demonstrate that, first, Operation Sparkles was lawful exercise of Erebor's right to self-defense. Second, the actions of the Skynet system are not attributed to Erebor. And finally, third, Genovia failed in its international duty to control its territory, enabling the Second Sons to threaten Erebor, thereby creating the conditions that made Erebor's defense measures necessary. Then, first, self-defense of Erebor. According to the Article 51 of the UN Charter, explicitly allows states to exercise their inherent right of self-defense in response to armed attack. Then, in this case, the Second Sons, the militant group, made a lot of violent cross-border attacks from bases located within the country of Genovia. These attacks pose a direct and ongoing threat to Erebor's territorial integrity and the safety of its citizens. Therefore, the Operation Sparkles was launched to neutralize the leadership of the Second Sons that were coordinating these hostile actions toward the people of Erebor, which for more than 30 years wished for a life without the participation of this group. Initially, the operation targeted military objectives within Erebor's own territory, adhering to the principles of proportionality and necessity. The incident involving Skynet's entry into Genovian territory occurred only after the system detected a new threat. Therefore, we cannot control the drone in these cases where he saw that threat incoming as not premeditated as an imminent danger. That required also immediate action. Hence, Erebor actions were proportional as the response was limited to neutralizing the specific threat and also necessary as no alternative measures were available. In second hand, I will talk about the non-attribution of Skynet's actions. The question of whether the action of Skynet can be attributed to Erebor depends on the principles of state responsibility, as codified in the draft articles of responsibility of states for international wrongful acts. From now on, RCWA. Article 8 of RCWA specifies that an act can only be attributed to a state if the state exercises effective control over the specific operation in question. Skynet, however, is and was an autonomous system in that moment that has no direct human participation, because once activated, it operated independently and Erebor's military personnel did not have real-time control over its actions. The example in this case that I would like to give is the Nicaragua case against the US of 1979, in which Nicaragua, the court ruled that the United States could not be held responsible for the action of the Contras unless it had an effective control over the specific operations. The same happens in this case, in which we didn't, and the Erebor's country didn't have an specific control over the drone used with artificial intelligence. So the unforeseen nature of Skynet response to hostile fire highlights, and Erebor cannot be held responsible for these actions that made the independent system. Interplace, I will talk about Genovia's responsibility for harboring the Second Sons. And now, another case that I would like to bring is the Corfu Channel case, which established that the states have a duty not to allow their territory to be used in a manner that harms other states. Why? because in this case Albania didn't notice the United Kingdom about the mines that were held in its territory, and that finally affected a lot of lives and people of the United Kingdom that were going through that sea. So that the ICJ concluded that the countries needed to make an advice and make contact with the other countries to make them understand, so to tell them about possible harms that could affect their sovereignty and their territory and their people, which didn't happen in this case. That where Genovia, although was held in the militant group Second Son didn't make anything to take them away from their territory, and that finally affected our territory and our people, facilitating the Second Son attacks that were directly threatening Erebor. Finally, I would like to talk about the compliance with international humanitarian law, which talk about the distinction and the proportionality. Why? Because in this case, the opportunity civilian losses were a consequence of the autonomous system's response to an imminent threat. And in order to what I just say, presiding judges and distinguished members of the court, the conclusion is that the Operation Sparkles was a lawful and act of self-defense under Article 51 of the UN Charter. The action of the Skynet system, being autonomous, cannot be attributed to Erebor. And finally, Genovia's failure to control the Second Sons and prevent its territory from being used for hostile acts contributed significantly to events in that question. The court, therefore, should recognize Erebor compliance with international law and reject the claims that Erebor violated the prohibition of the use of force. Thank you so much.
Distinguished members of the court, I speak today on behalf of the Republic of Erebor to discuss the second legal issue, which focuses on Genovia's intervention in our embassy and the unlawful seizure of diplomatic materials. So, the legal issue is, does Genovia's judicial intervention in the Erebor embassy and the seizure of its assets, including computer equipment and documents, constitute a violation of international norms? To start, we could say that this act constitutes a clear and serious violation of the Vienna Convention on Diplomatic Relations, a fundamental treaty that guarantees the safety and immunity of diplomatic premises and documents. So I will demonstrate the following. Firstly, Genovia's actions clearly violated international law, and second, Genovia has not valid legal justification for its actions. So first, violation of diplomatic inviolability. So the Vienna Convention on Diplomatic Relations establishes inviolability as a cornerstone of diplomatic relations between states. So Article 22 of the Convention explicitly states that the premises of the mission shall be inviolable. This means that no state under any circumstances may enter an embassy without the express consent of the head of mission. In this case, Genovia entered Erebor's embassy without permission, disregarding this obligation, and such actions undermine the trust and legal framework that make diplomacy possible. And the Article 24 further extends this protection to the archives and documents of the mission, ensuring their inviolability at all times and places. By seizing computers and other materials from Erebor's embassy, Genovia breached this provision, and these materials likely contain sensitive diplomatic communications, making their seizure even more egregious. These rules are absolute and allow for no exceptions, even during times of crisis or increased tensions. It's also important to know that both Genovia and Erebor are parties to the Vienna Convention on Diplomatic Relations. Therefore, disputes between the contracting party regarding the interpretation, application, or execution of the convention may be submitted to the International Court of Justice. at the request of one of the parties to the dispute. In the specific case, as both are parties to the convention, Erebor has the standing to act in defense of its obligations and interests under the convention, even if it were not directly affected by Genovia's action, for example. In this way, the nature of the obligation established in the convention are considered erga omnes parties, so that each state party has a legal interest in their fulfillment by all other states parties. The second point is the supporting legal precedents. In this section, we will explore how leading cases adjudicated by the International Court affirm the inviolability of diplomatic premises. So, for example, in the United States diplomatic staff in Tehran case, this court condemned Iran for failing to prevent the seizure of the U.S. embassy and its staff. The court emphasized that diplomatic premises are inviolable and that any violation constitutes a breach of international law. In its ruling, the court found that Iran had violated its international obligations by failing to prevent and punish the actions that led to the hostage taking and the assault on the embassy. Although the ruling did not focus exclusively on Article 24, it did reaffirm the inviolability of diplomatic missions and their documents as part of the broader framework of international law. So, Genovia's actions are directly comparable to this case by entering Erebor's embassy and seizing confidential materials. Another point is the invalidity of Genovia's justifications. So, Genovia might argue that its actions were justified by, for example, the first national security concerns or the need to investigate potential violations of international law linked to Erebor's Skynet program. However, neither of these claims can justify its action under the Vienna Convention. The convention, for example, provides no exceptions to the principle of diplomatic inviolability, not even for reasons of national security. Genovia cannot justify its intervention in the Erebor embassy by invoking its domestic law, as international law prohibits the use of domestic law to excuse non-compliance with international obligations. According to Article 32 of the Articles on State Responsibility, ARCIWA, a state cannot rely on its domestic law to avoid fulfilling its international commitments. In this case, the Vienna Convention on Diplomatic Relations, to which Genovia is a party, provided that diplomatic missions and their documents are inviolable with no exception for reasons of national security. About the reparations under international law, we could say that Erebor is entitled to full reparations under Article 31 of the draft Articles on States Responsibility. Genovia must take the following steps to restore Erebor's rights. For example, first, return all seized materials. This includes the computers and any other property taken from Erebor's embassy. The second one is the provide financial compensation. So Genovia must compensate Erebor for the material and reputational harm caused by its action, for example. So these reparations are not just a matter of justice for Erebor. They are necessary to uphold the integrity of international diplomatic law. In conclusion, Genovia's intervention in Erebor's embassy and its seizure of diplomatic materials represent a grave violation of international law. This court must, for example, first declare Genovia's actions unlawful, and the second one is order Genovia to provide full reparations, including the return of seized materials, financial compensation, and warranties of non-repetition. Thank you.